Johnson, Councilmember Englander, and Councilmember Price all are present. If I could ask the city clerk to please bring me my public comment cards, and we will get started.
Hello, brother.
We'll start off with the multiple agenda item comments. Those are for items where people have chosen to speak on more than one item. We give them the opportunity to speak on those items up front. Daniel Friedman, items 2, 4, and 5. Total of 2 minutes. Welcome.
Chair Weezar, can I speak on each item individually? I'm not sure if I want to speak on two or not.
Yeah, if you chose to do, what's the rules? No, we have these up here. You have to speak. We'll give you 2 minutes to speak on the 3 items. Because you could speak to choose on one.
If I withdraw two,
If you
can I speak on the other two?
What do you mean? Like if you withdraw two, what do you mean?
Tricky
All right,
math you're doing
just-
there. Tricky math.
It's just,
Hey man, I just implement the rules. I didn't make these
I got
rules.
you. I got you.
know?
I just totally was not necessarily
They told me
prepared.
to do these
I wanted
rules.
to see
I'm
some
sorry.
presentations first. Okay. Chair Weezar, members of the Planning Land Use Management Committee, thank you so much for having me. I just had a few comments I wanted to make, particularly with respect to item number 4, which is the modification of the Cultural Heritage Ordinance. Our office submitted a letter later yesterday afternoon with some comments that we would like you to consider as you're considering the modified ordinance. In particular, there's some big issues regarding notification as well as process that I think you can make some very reasonable amendments to and make it a better ordinance. In particular, we are recommending that the applicant be required to provide notice to the property owners as part of the application process. As it's designed right now, the ordinance allows for an application to be deemed complete, which creates a stay, but the property owner isn't given notice until after that stay is implemented. We think it's just a disaster in the making, and we think it can be a quick fix up front. The other issue we really hope you can clarify in the ordinance is that what occurs when there's a deemed denial. So there's all these areas of the ordinance which provide there's a deemed denial or a recommended denial. We think we could have a very clear provision in the ordinance which basically states that if it's denied or deemed denied, that a new application can't be resubmitted for a certain amount of time. Generally, the planning department has a procedure where if you are denied an application, they won't accept the new application within a certain amount of time. We think it makes sense to have this process in place, especially with historic monument nominations. It'll help cut back on serial nominations. And then finally, we had also suggested that there be a deadline for applications to be deemed complete. So as it currently stands now, when someone submits a historic cultural monument nomination, the Director of Planning through the staff can really just sit on those applications. We're just hoping that there can be a deadline that after a certain amount of time that it's either accepted or deemed denied. Thank you.
Okay, thank you. Okay, so now we will go through some items that if there are no public comment cards, we will take on consent. Item number 2, which is a motion by Rue relative to instructing the planning to prepare a hillside construction regulations zone change ordinance to 2 neighborhoods in CD4. Item 6, ordinance by O'Farrell, or it's in O'Farrell's district ordinance amending the Vermont Western specific plan to allow for construction of a community garden at 1175 North Madison Avenue. Item 7, VZC and HD changes in 4 appeals relative to a 21-story, 275-room hotel at 6407 West Sunset. That will be continued to May 2nd. Item 7 continued to May 2nd. So we'll have items 2 and 6 on consent. Item number 3. CAO report relative to interim position authority to implement development services reform, bill delay. If you could call that to order real quick, and then we'll go to item 1 after that. Yes.
Item 3, Councilman, is a report from the CAO relative to position authorities for the development services reform strategies. CAO is present.
Okay. Welcome.
Good afternoon, council members. Jason Klein, Office of the City Administrative Officer. Before you is a list of recommendations to give the Department of City Planning, Department of Transportation, and Office of the City Attorney interim position authority to allow for the Personnel Department to allocate positions in the current fiscal year that we anticipate being filled at the end of this current fiscal year or early next fiscal year. All these positions are intended to support programs that this committee has adopted over the recent months. There are positions associated with the expanded community planning program, the modifications to the environmental impact review process, as well as opening the West Los Angeles Development Services Center and expanding services to after hours, and ensuring that our cycle times are within the recommended goals from the Development Reform Incentive Report. If you have any questions, I can address them.
Great, thank you. No, I just wanted to point out that in this is something that this committee has been working on for quite some time, and that is to approve the positions that will go towards supporting our expanded community planning program. And so it's good that we're moving forward on this as quickly as we are. Thank you for that. Any questions or comments on this? Seeing none, we'll approve that item without objection.
Thank you, sir.
Okay, thank you. Item number 1, report from Director of Planning, Ms. Bartoni. Come.
Thank you, Chair. Committee. Just one quick item on Thursday, May 23rd.
One second. I don't think you're. Is it on?
How about now?
No, it's not. It's not on. Maybe speak into this one, if that's okay. Or is it on? I can't hear it. Yeah. Thank you.
This is working. Okay.
Yeah.
Sorry about that. Okay. So, Chair Weezar and members of the committee, Vince Bertoni, Director of Planning. Just one quick item on Thursday, March 23rd. We had a special joint meeting of the City Planning Commission, the Board of Airport Commissioners, or BOAC, that regarding the Land Side Access Modernization Plan, or LAMP. So that was heard by both of them, both the City Planning Commission and the Board of Airport Commissioners, and they recommended approval of the project to the City Council. So you'll be having that come to you in the future. And with that, it concludes my report, and I'm happy to answer any questions.
Okay, great. Well, thank you. Thank you for that work. Any questions? Seeing no questions, we will receive and file item number 1 without objection. Okay, now we could turn to item number 8, please.
Thanks.
Item 8, Councilman, this is an appeal by Mr. Baluvi Patel. He's appealing the revocation of the use of the Adams Garden Inn Motel in CD10.
Okay. We have with us here someone from CD10, Jordan Barokim. Do you wish to speak before or after? Presentation after? Okay. LAPD will reserve as well for after the appellants make their presentation. Appellant and appellant rep, Frank Weiser and Bai Bahai Pagel. Welcome. How these proceedings work in this committee is the appellant has 5 minutes. You could either share that time between the appellant and the appellant rep, and or reserve 1 minute for one person that did not speak within those 5 minutes.
And I'm Frank Weiser. I'm the appellant's rep.
Okay, welcome.
I'll try to be as brief as possible. First, we do object to the Plum Committee being the primary appellate board here to hear the appeal. I think we do have a procedural due process right to hear it before the whole City Council. I just want to reserve that as a constitutional objection. But getting to the substance of the appeal, I submitted to the clerk this afternoon a First Amendment complaint in the federal district court, United States District Court case that Mr. Patel filed prior to the zoning administrator's decision that we are now appealing, and also a civil docket of the case itself, and that is Balubhai Patel, and there are various other plaintiffs, and including plaintiff tenants at this motel versus the city of LA. In that case, we're challenging the original decision by the zoning administrator and by the council to impose the conditions. Whatever the merits that the city may or city attorney's office has regarding the case, it's not final. There was a motion to dismiss. We've actually appealed the underlying decision in a state supplemental claim. In the case, we're claiming there's no statute of limitations because the city did not afford the proper notice under Code of Civil Procedure 1094.5 and 1094.6. The district court judge took the motion under submission, and it is now submitted. There is no final ruling. Even if there were a final ruling, the city is claiming that we should be going to state court and that the district court should abstain. The case would be not final, and the rule is very clear. Until a appellate court rules on the merits of this case, you do not have a final judicial decision. So I think that aside from the legal arguments that we raised, that we don't have a final order, it would be highly imprudent for the city to revoke and go forward on this revocation while we are challenging the underlying order. We did submit also at the zoning administrator's hearing evidence from the plaintiff tenants. These are minority, poor people who are living there, who've lived there for a long time. Some of them are disabled. They have no other place to reside. We raised an issue under the Federal Fair Housing Act. That is also a part of this lawsuit. The city had a duty to reasonably accommodate those people. That's not part of the zoning administrator's order. I think she's placing the burden on Mr. Patel. So I think that there was a rush to judgment here. I think we have a right to exercise our due process rights before the city takes any action. We don't think that the evidence supports that this property is the nuisance. The nuisance activity, I believe, is coming from several blocks down from the motel. The motel is gated, and nobody has ingress or egress without the motel manager. So a lot of the allegations I know LAPD is making is not coming from the motel. With that, I would ask that the committee sustain the appeal, reverse the zoning administrator's decision.
Thank you. Okay, now we will hear from LAPD Officer Livingston. Sir, I have just one card for Officer Livingston from LAPD, but any officer wishes to come up and speak as well, that's would be appropriate at this time. Thank you.
Good afternoon.
Good afternoon.
I've been assigned a Detective Sport Vice Division for LAPD for approximately like 10 years. Garden Inn has been one of the cases that I've been working on from approximately since 2006. Now it came back up in 2013 where I received it. From 2013 to 2016, I've conducted 26 inspections at this location. Out of those 26 inspections that I conducted, on 15 occasions I tried to meet and talk to the property owner with no success at all, meeting with this individual to talk about the conditions and the activity and the nuisance activity around an area. I've reached out to Mr. Patel on by just doing upfront inspections, leaving business cards, and also leaving voicemails with no regards to that. This year, out of the inspections I conducted, I ended up citing the location twice for conditional use permits. Out of these permits, these conditional use permits, the location itself, every time we go by there, it's always some type of Activities occurring, graffiti, lock gate, no security. At one time, he had an actual individual pop up and to be the security for the location, which is just an individual that was residing at the location. There's been times where I've seen little kids playing in the courtyard as well with no supervisions. On top of the location, a lot of marijuana activity is occurring there, a lot of narcotics activity there. Out of these 26 inspections also, this is just inspections that my partner and I conducted ourselves, not along with Southwest Vice and other individuals from our division. Now, from this year, there's been a total of 9 calls at the location from January, 7 calls from the intersection, and there's been 6 reports from the intersection and 4 reports at the location in itself. Again, like I said, I have reached out, and at no time the property owner has done anything to correct any of these deficiencies and what I observed in these. Also, I talked to the property managers. At this time, since I've had this case, it's been 3 different property managers at this location. So what I've been looking at into the property itself, reaching out, I attended a community member, reached out and talked to community members, and also attended meetings and listened to the communities about the activities occurring, the safety issues of kids walking to and from school, people walking in and out of the location, concerns, the safety issues of the children. Again, with the lock gate not being secured at no time, of all the inspections I conducted, out of the 26 that I've done, it's never been locked. We done undercover investigation at the location, and he's been cited again for conditional use permits of deficiencies occurred at the location. And that's all I have right there.
Thank you very much, sir. Jeremiah Adler, David Catenessa. Welcome.
Good afternoon. We are actually representing the party that's in escrow to purchase the property. And my partner here is the operator, so he could give you a little idea of what it is that we have in mind in order to, basically it's a completely different use from what is currently at the location.
Yeah, I own Upstart Creative
Okay,
Living.
one moment, sir. Can you hold their time, please? We have the speakers speak per 1 minute each, so when you complete your time, then we will have the other person speak. You have 36 seconds left if you want to use those, or you could go, if that was all you had to say, that's fine. I just wanted to make you aware of that. You're Jeremiah?
I'm Jeremiah.
You're Jeremiah, okay.
David.
You're David, okay. So David, if you want to finish up now and then have him speak, or if that was it for you, we could go to Jeremiah.
Yeah, I mean, basically the idea is that we're changing the use to a co-living space. It's not at all a motel. And that way, you know, hopefully, if we are able to kind of let you understand what it is that we have going on, maybe we could get an extension of time or something to show that once we are in operation, we will be able to prove to the city and to all parties involved that this is not at all a motel or operating as a motel. And he'll be able to explain better what it is that we do. Thank you.
Thank you.
So I own Upstart Creative Living. It's affordable housing for artists, actors, musicians, DJs, painters, everything like that. We have 3 locations open in Los Angeles right now. We think this place in West Adams would be just perfect. Basically, I mean, we have a low price point, $695 per person. We're going to completely renovate the property inside and out. Right now, that corner is sort of an eyesore. We really want to make it a hub in the community. You know, where there's other than complete renovations, you know, part of that would be vacating what we understand are the current troublemakers there. Everyone that we admit will be going through a criminal background check. We're going to have a full-time on-site staff there of at least 4 people. And, you know, let's see, we're also going to be doing classes for youth, art classes, music classes, stuff like that. Thank you.
Thank you. Jordan Barokim from CD10.
Good afternoon, members of the Plum Committee. My name is Jordan Baruchim from Council President Herb Wesson's office. We are here today to ask that the committee please deny the appeal and sustain the decision of the zoning administrator to revocate and shut down the motel use at this location. The establishment has posed a threat to the community and serves as a destination for criminal and gang activity. Issues and concerns have been lurking around the establishment since Council President Wesson was a deputy to former Councilmember Nate Holden, which dates back to the late 1980s. Conditions have gotten so bad at the site, it's gotten to the point where our office provides funding for security services to service the art center that's just to the west of the site, if I'm not mistaken. And the security service not only secures the art center, but the alley in the back that leads to the motel as well. It is evident by LAPD attendance here today that problems still occur at the site today. LAPD was here 2 weeks ago as well, back when the item was originally noticed for hearing, and they're back again today, so that really shows a lot to our office and to the community. If you recall, I mean, this item was before the Plum Committee back in October of 2015 regarding the same matter. At the time, we were simply imposing conditions on the operator, and as one of the conditions, they were supposed to come back in for a plan approval, which they did not file. And so as a result, the city initiated another revocation. So we feel that the city has the necessary findings at this point to justify revocation. Let me see. Again, we ask that you please deny the appeal and discontinue the motel use at this location. And if you have any questions, I'm here to answer. But again, we please ask that you deny the appeal. Thank you very much.
Thank you. Is planning staff here on this item?
I believe so.
Yeah. Okay. There were some speakers here. If you could sit down here in the front of the table, please, if that's okay, just to answer a few questions. So the revocation that's proposed, would that run with the land? And so it's for all future uses. So if there's a new owner of the land, would the revocation and its prohibitions of operating as a motel and similar uses apply to new ownership?
Alita James, City Planning Department. That is correct. The conditions and the action will run with the land under 12.27(1) of the Municipal Code. Also, if the use is to be considered as changed, in the event that the actual existing use is revoked, the business operator or property owner may file for an application for modification of an administrative decision, which is under the code section 12.271(e). We would ask that if the use is the same, if they're coming back with a motel or similar type operation, the code requires that they wait a period of 1 year prior to filing an application whereby we would consider a modification. If it is clear, based on their application or project description, that the use has significantly changed, or it is clear that it is a new use, they may file an application at that time.
Okay, so the relief for the new owners is if, in fact, they turn it into something new, as the individuals who made public comments say they are under escrow. If they totally change this and come back within a year, put in an application, I'm sure there'll be some review, LAPD as well, to say that there are no more problems. That's their relief, that they could then not be under these conditions, correct?
Correct.
Okay.
They must show the substantial change in the nature of the operation of the land use.
Okay,
at the time.
great. Thank you. And to our city attorney, the representative for the appellant stated that there is a parallel legal track that this is in. Is that accurate, or?
Terry Kaufman, Messiah City Attorney's Office. There is a federal court action pending right now, but that is, you can still go forward with this proceeding.
So it's
despite
not
that.
premature for us to act on this, as was stated by the
No.
appellant? Okay. So okay, great, thanks. Any other further questions or comments? Nope, okay. Well, thank you very much. And, we often hear these cases, and one of the things we had hope that happens is that the owners of the property communicate at least with LAPD and/or city staff to see if some of these issues could be resolved. In this instance, it appears that attempts by the LAPD to communicate with the owner of the property were little to none, although there were some attempts to do so. And even that's a great sign that shows me why we should move forward and deny the appeal, given that the property owner didn't even want to have a conversation about some of the allegations. So we'll move to deny the appeal. Any objections? Thank you very much. So ordered. Item number 4.
Item 4, Councilman, this is a report from the City Planning Department. It's a proposed ordinance to make changes to the city's historic cultural monument designation ordinance.
Welcome.
Yes, good afternoon, council members. Ken Bernstein with Department of City Planning and Office of Historic Resources. We're here today to present the proposed procedural amendments to the Cultural Heritage Ordinance, which is our city's historic preservation ordinance for the designation of individual properties. We also have subsequently our ordinance on historic preservation overlay zones or historic districts before you today. There are four procedural changes being proposed to the Cultural Heritage Ordinance. Perhaps the most significant one is to provide earlier notification to property owners of pending historic cultural monument nominations. The current ordinance actually does not give any notice to property owners that a nomination has been filed until after the Cultural Heritage Commission holds an initial hearing to take the nomination formally under consideration. This leads to situations, I think some of you've heard some of this in Plum over the years as well, where property owners feel blindsided that they were not aware of the nomination itself, and also blindsided that they were not able to participate in the first hearing on a proposed historic cultural monument affecting their own property. The proposed amendments would remedy this by requiring notification of the property owner once the nomination has been deemed complete, and would provide notification of the date of the first hearing. This would provide more appropriate due process and enable owners to participate in all aspects of the public hearing process affecting their properties. Complementing that procedure as well is under this proposal a stay on demolition while a nomination is being considered would begin after an application is deemed complete by staff and scheduled for the Commission's hearing, rather than the stay going into effect after the initial Commission consideration. The reason that can't happen today, again, is that the reason we can't notify owners, the stay only goes into effect once the Commission acts, and only then are owners notified. So this is coupling the earlier notification with the owners to the earlier stay in effect on demolition, which would allow the ability to notify owners in the initial public hearing without potentially triggering a preemptive demolition. And finally, there are additional procedural changes to allow for 60-day time extensions with the a written consent of a property owner. We've had a number of situations at the Cultural Heritage Commission where owners would like additional time to respond to a nomination, but because we are very time limited to 75 days to consider that nomination, those property owner requests cannot be granted currently, so this would enable up to 60 days of extensions. And finally, the proposed ordinance changes would clearly demarcate the designation criteria. We are making no substantive changes to the designation criteria, but breaking them out individually and making clear that the section that today reads definition of a monument actually represents the criteria for historic designation, and that the criteria mirror other levels of designation, such as the National Register of Historic Places and the California Register. So those are the four major changes, and happy to answer any questions the committee may have.
Great. Thank you. I think, Mr. Friedman, I know you submitted a letter. I didn't get I don't have it before me, as you mentioned, but you mentioned three of your points. They did raise my interest in terms of the issues you were raising. One was the applicant required to receive notice to the property owner, but that is in here. I wasn't quite sure I followed that. that point you made.
Yeah, thank you, Councilman. And I just wanted to start off by saying we support these amendments. Actually, some of these amendments started because of a case that my partner Ben Resnick and I had, and Councilman Englander helped get the process started to make a lot of these amendments, which we are generally supportive of. The issue with notice that we have when we reviewed the ordinance as proposed is that the way it works as it's proposed is that an applicant will come in, submit an application for historic cultural monument status designation. What will happen then is the Director of Planning or through the staff will review the nomination and then deem it complete. At that moment it's deemed complete, a stay is issued. So it's essentially as soon as that application is stamped as completed, a stay is created. Now, the owner doesn't get notice of that stay until certified mail is received by them. So a mailing is sent after that application is stamped, and then the owner gets notice. And so I guess what my partner and I see coming down the pipeline is an application is going to get stamped in the Office of Historic Resources. They're going to demolish or construct, whatever it may be, and then 2 days later they're going to get a certified mailing saying there was a stay issued on your property. And we just don't see why there wouldn't be a requirement, just like there is when I go in and ask for a planning entitlement, that there's a requirement that I go to BTC and provide notice to all of my neighbors, that why wouldn't there be a requirement as part of an application that there be a notice provided to the property owner by the applicant. Now, I understand the concern about property owners rushing to demolish, but I don't think it's right for the city to have a process in place that automatically doesn't trust property owners to do the right thing, that is trying to ambush them with a stay before they know. I don't think we should have an ordinance that strategizes around that. Okay. And then one last thing I wanted to note, and if you have additional questions, I'd like to address them as well, but the actual criteria have been changed. There were revisions to the criteria as part of this modified ordinance that I do believe are significant. Words were changed in the criteria definitions that actually make it a lot looser to nominate something and designate something, which I'm concerned about because we just went through a hearing on some other properties where the standard seems to be if it looks like an old property and it is an old property, then you can find a way to designate it. And we have concerns about the broadness of some of the criteria, and some of the revisions are even broader.
So my other question to you was, you also mentioned something about people being able to resubmit an application if it was denied. Is that in the ordinance right now? Or people can't?
There is nothing in the ordinance that precludes.
You could always resubmit. And your view was that there should be some type of, I don't know, you hold it, can't resubmit an application for a certain amount of time or something.
Planning was just here on the previous item, and they said that you can't resubmit to modify your conditions by policy within a year. We think it would be reasonable that there should be some policy or some statement in the ordinance that says if it's denied for any reason that it can't come back to the commission within a certain amount of time.
So thank you very much. Thank you. So back to our planning department on Mr. Friedman's first point.
Happy to respond to each of these. With respect to his first point, I would like to point out that currently, in terms of notification to property owners, there is no notification of a stay going into effect until after the commission has actually taken a first action. So not only has, at that point, staff deemed an application complete, but the commission has actually held a public hearing without the participation, typically, of a property owner in this situation. Only then is the property owner notified and the stay goes into effect. What we are proposing is to have a process under which once the application is deemed complete, yes, a stay is going into effect. That lengthens the time period, perhaps by a couple of weeks that the stay would be in effect, but the owner would be able to participate in all steps of the public process, be at that first hearing of the Cultural Heritage Commission. So the stay provisions are not significantly different, but the level of due process and notification is significantly enhanced.
Well, and I agree. Providing notice is a significant step forward from not having one at all. So now it's an issue of when. And it seems appropriate to me to have it when it's deemed complete, when we know there's going to be a process. Well, it may or may not be deemed complete, so why alert this and have all this fuss beforehand when, in fact, there's no process in place or nothing's going to...
And what we're talking about is concern about a small minority of cases where the owner is objecting to the designation. The vast majority of nominations that we see are submitted by the owner or are supported by the owner. So the ones that are controversial or have discussion here typically are those handful each year where there is an owner objection. And in some of those cases, we do have the imminent threat of demolition pending. So it is a concern that there could be a time period under which an owner could alter or demolish a structure before a stay goes into effect.
And as to the second point on resubmitting an application within a certain amount of time, I mean, what's our standard procedure here in the city for other types of applications, not just historical nominations, but I don't know, do we ever deny anybody a certain amount of time from reapplying? I don't know what our standard procedures are here.
I'm not certain, actually, in terms of other types of entitlements. These types of applications are a bit different than entitlements, and there certainly could be a potential concern about an outside party abusing that process. We have chosen to address this issue not through the ordinance language, but through separate policies and procedures that govern the work of the Cultural Heritage Commission. And we have a procedure that's been in place for, I think, more than 15 years about previously denied nominations, not in the ordinance language, but it states that if there has been a previously denied nomination, a subcommittee of the commission needs to consider a resubmitted application and determine one of two things. Either that significant rehabilitation work has occurred since the nomination was previously denied, or that there is significant new information not presented in the original nomination. So that is in the commission procedures. That's a process that has worked well and enabled us to deny essentially the more frivolous requests for resubmittal if we've had that situation. The commission subcommittee is able to make those determinations.
And I just thought of something. What if somebody doesn't want any work to be done on any property, and then you just continue to resubmit applications? There's a stay forever. Right?
Only if an application is deemed complete. So again, we would have a process by which the commission would, before we got to that process, with those procedures, determine whether there's significant new information that is, or rehabilitation work that's worthy of reconsideration.
Okay. Well, that's a worthy issue that I think, from my point of view.
And just the third point Mr. Friedman raised was on the criteria. I do just want to confirm that there are not substantive changes that have been made to the criteria. They're just broken out differently. It's not a lower bar in any way. It is the same standard that is used today, just expressed slightly differently and broken out slightly differently, but substantively the criteria are the same.
Okay, thank you. Any other questions or comments?
You have a comment card?
Comment card? Oh, I'm sorry, I didn't see any. Maybe it was submitted after I took the... Oh, yeah, we do have two. Sorry about that. All right, Bill Delbeck. Sorry about that. Didn't see this.
Quite all right. Honorable Council members, Bill Delbeck. This is a rare event for me to be here without representing any particular interest other than myself. It's critically important in creating policy to not let perfect be the enemy of good. The amendments before you are good. I have had a number of clients, I probably have represented more people opposing nominations than others, although I've represented people supporting them. The single biggest complaint, other than why would I get designated, is this notice issue. It is not feasible to give an owner notice and then have a process. If we're interested in preserving resources, and candidly, I am interested in preserving resources, but to have a hearing that an owner hasn't been at is just a mistake. This ordinance addresses a problem that was created in 1962, and it does it in a good way. I have had the commission turn down nominations at the under consideration stage, and it's very important for owners. Also, I think the 60-day extension is also very important. Thank you very much.
Thank you. Faisal Al-Sari from Council District 5.
Council members, good afternoon. Faisal Al-Sari on behalf of Councilmember Koretz. Just would like to offer one friendly amendment here to this item. We recently had a case in the 5th District where the Cultural Heritage Commission lost jurisdiction due to time limits because they were unable to actually physically meet before that time. The city should have adequate time to review merits of these cases. Oftentimes, these cases involve highly technical information. There is a tremendous amount of research that goes into these cases before they actually come to commission. We therefore request your committee to consider a proposed amendment to this item, CF number 16-0126, to allow the Director of Planning to extend this time limit with mutual consent of the applicant. The department has reviewed and recommended this language, which I'm submitting to your committee today. Basically, that is the primary change, is just to allow the Director of Planning by mutual consent of the applicant to extend that time limit. Therefore, you won't have situations where if the commission just can't meet, you won't lose jurisdiction over a case. Thank you.
Okay, thank you. The Planning Department, have you, this is the first I hear of this amendment. Have you had time to review that amendment? What are your views on it?
Yes, again, Ken Bernstein. Yes, we have had an opportunity to review the amendment and are supportive of the intent. This is specifically with respect to the 30-day time limit between a case. There's a requirement currently from the time the director deems an application complete that it must have its initial consideration hearing within 30 days. And as Mr. Alseri mentioned, that time limit can be problematic if there's a meeting that's canceled and so forth. So this would allow, by mutual consent of the applicant and the director, for that time limit to be extended. And that still would not deny any due process for the owner. They would have been notified at that point, be able to participate in all the hearings.
Okay. My staff who read this ordinance in and out, you guys are okay with this? Okay. Thank you. All right. We got the okay from Kevin over here. Oz behind the curtain that controls planning in CD14. Mr. Friedman, I usually don't allow this, but since you brought up some very interesting points that added to this conversation, I will allow you to just say what you have to say.
Thank you, Councilman. And I'd like to echo Mr. Delvac's comments. I'm participating out of pure interest. This is not out of advocacy capacity.
Yeah.
And out of trying to be supportive of the city's efforts here, because we do support the edits, and I agree that the notice is very important. It's a huge upgrade and a huge improvement for the city. Where we're just concerned and where I see a big issue and where we hope we can get a fix before it becomes a problem is the idea of an application on someone's property being designated, submitted to the director, and it basically becomes a ticking time bomb for this property owner for when the moment the director stamps the application complete. Because once that happens, everything changes for that property owner. Now, we understand that that's going to happen at some point in the process. The question is, are there ways to ameliorate that for the property owners? And we suggested a couple ways. One would be require notice before the application is submitted, so that at least they know, they have knowledge that an application has been submitted on their property. Another way would be to have a deadline for the director to stamp it as complete. Right now, there's no deadline, so this application can be submitted in March, and it could sit for months until the director of planning decides to stamp it, and then there's a stay. And we think that creates a lot of problems. For example, if someone has a project in plan check, they may have enough time to start their project. And then it'll be, someone will come run you the director of planning and say, you better stamp this application as complete, so you stop them. And then the director of planning will stamp it as complete.
Okay, thank you.
We just think you could put in certain protections that would help the process and be safer for everyone.
Thank you.
Thank you.
So my following question to our planning department is, what are the pros and cons of giving notice to the property owner when the application is submitted as opposed to when it's deemed complete?
Again, I think the concern would be providing an opportunity, if notice were provided when an application is submitted, that there would be a window during which that potential historic resource could be demolished or altered. And again, the reason we are providing this new opportunity for early notice is that we're pairing that with a slightly earlier stay on demolition and alteration activity. So we think that is a significant advance from where we've been and where this ordinance has been over more than half a century. But creating a window for the loss of a resource is a significant concern. And we have lost historic buildings during the time period between an application being scheduled for the commission and the time the commission has met. We had a case in Echo Park this past year where a significant, potentially significant historic home was lost. One of the earliest homes in Van Nuys was demolished several years ago on the eve of the Cultural Heritage Commission meeting. So there is that concern that we'd be opening a wider window for that type of activity.
Thank you. Any other questions or comments? Okay. All right, seeing none, so we will move to approve this item as amended by Councilor District 5. The language has been submitted on the action on application. And
So
although, yes,
The directive, Councilman, is to request the city attorney to prepare the ordinance along with the amendments by CD 5.
there you go. Thank you very much. And we will still have some time to consider any other issues as brought up. There's some good discussion here, but thank you. Any objections to that direction? Seeing none, so ordered. Thank you, and thank you for your work. Item 5.
Item 5, Councilman, this is a city attorney prepare ordinance to make amendments to the city's historic preservation overlay zones ordinance.
Welcome.
Good afternoon. My name is Blair Smith of the Department of City Planning, Office of Historic Resources, HPOZ unit. The item before you today involves amendments to the HPOZ ordinance. The City Council adopted the ordinance enabling the creation of HPOZs in 1979. Subsequent to its adoption, the HPOZ program has grown substantially, with 3 HPOZs adopted in the 1980s, 6 in the 90s, 14 in the 2000s, and 12 adopted so far in the 2010s. Today, the City of Los Angeles has 35 different designated HPOZs, with 10 currently under consideration. With limited staff resources and an expansion of the program expected ahead, amendments are needed to the HPOZ ordinance to improve review procedures and clarify implementation procedures. As such, we propose to modify the procedures for the technical correction of a historic resources survey so that technical errors can be resolved faster. We've created more proportional thresholds for the review of projects so that rather than reviewing all sites and lots the same, thresholds are now tailored to the size of the structure and lot. We've improved regulations for non-contributing properties by allowing the HPOZ board to review projects for conformance with design guidelines and therefore prevent projects that could impact the integrity of the historic district. We've allowed for a board to serve multiple HPOZs so that communities that would like to work together can do so. We've addressed demolition with and without permit by clarifying at what point demolition occurs. And finally, we've relieved street dedication requirements, and in doing so, protect the historic curb and street configurations. These changes reflect the department's overall goals to more efficiently manage the implementation of the Historic Preservation Overlay Zone program as we continue to expand and to continue to protect Los Angeles' historic neighborhoods as they grow and evolve. Thank you.
Thank you very much. Any questions or comments? Seeing none, well, no public comment cards. We'll move to approve the city attorney prepared ordinance. Is that correct, Roberto?
Yes, Councilman.
Thank you. Any objections? Seeing none, so ordered. Thank you. Item 9.
Item 9, Councilman, this is a report from the Cultural Heritage Commission, which is recommending disapproval of the inclusion of the Dr. and Mrs. Burton Fletcher residence as a historic cultural monument.
Good afternoon, Chairman Weezar and members of the committee. I am Melissa Jones with the Department of City Planning's Office of Historic Resources. Before you today is the Dr. and Mrs. Burton F. Fletcher Residence Historic Culture Monument application. The subject property is a 1963 French Revival-style single-family residence designed by architect Wallace Neff. This is an application that was initiated by City Council's adoption of a motion introduced by Council District 5. As you are aware, the nomination was initiated amidst pending demolition. Councilman Koretz initiated the nomination because he felt that the property exemplified the work of master architect Wallace Neff, was one of his last houses, and was unaltered since it had been built for the original owners. The staff recommendation was that the property met two of the criteria as a notable and highly intact example of the French Revival style architecture and as a work of master architect Wallace Neff. Upon review of the application against the four criteria of the Cultural Heritage Ordinance, the Cultural Heritage Commission recommended declination of the property as an historic culture monument based on a lack of evidence. The commissioners were not able to access the property to conduct a site inspection. I'm here for any questions that you may have.
Thank you. We will go to public comment now. Okay. First is the owner's representative. Elia Thompson and Curtis Fortier.
Elliot just stepped out to take a bathroom break. Curtis will give his statement. Hopefully she'll be right back.
Oh, okay. So Ella Thompson?
She went to the restroom.
Oh, she went to the restroom?
Yeah.
And how about Curtis Fortier? Okay, welcome, sir. So how do you want to use your time? Do you want to...
Elia's right here.
Okay. So you have a total of 5 minutes. One of you could take the 5 minutes, or both of you could take the 5 minutes, and then one person take the 1 minute if you wish.
Hi, I'm so sorry. That was quicker than I thought. Elia Thompson. I am the land use attorney hired for the property owners. So I don't want to go through everything that we submitted. We did submit a pretty hefty packet of documentation, including a report by Kaplan Chin Kaplan. All of you should have copies of it. And I'm so happy that we're here today when you guys are considering adopting some changes to the way the notice happens, because to be clear, this property was vacant for 4 years. For your record, the only owners of this property is Cashew Hill. The Fletchers do not own this property and haven't for over 4 years. So we appreciate the time the Cultural Heritage Commission took in determining whether to deny this cultural designation, given that the property did not meet any of the criteria. And to be clear, the author, Pam O'Connor, is here in regards to the historic report. She's here for any questions. She's not going to do a presentation. She's been battling bronchitis, so we're going to give her voice a rest. But if you do have any questions, she's here. And as stated in our letter, the property's been vacant for more than 4 years. It can't be seen by the street. Our client has had this in plan check for 20 months. Curtis is our expediter and has been working for 20 months in plan check. In December, they had their haul route hearing. No one showed up. No one opposed. They pulled all of their permits, and it was only when they went to pull their demo permit about a week and a half before the hearing in front of Cultural Heritage Commission did a hold appear, and they suddenly realized that this was happening before Cultural Heritage Commission. So again, for all the reasons you guys previously discussed, I'm glad that some of the noticing issues will be rectified in the procedure you discussed before this. For all the reasons in all of our documentation, we hope that the City Council will uphold the decision of the Cultural Heritage Commission to not designate this property as a cultural monument. And finally, I want to say for the record, I want to apologize if any of my comments made in our documentation was considered aggressive or political, especially to Councilman Koretz's office. Our team personally reached out to numerous neighbors to this property, and none of the neighbors that we spoke to supported the designation or opposed our construction. We are pleased to hear that Councilman Koretz accepts the decision of the Cultural Heritage Commission to deny this designation. And again, I'm sorry I ran in here, but I'm available for any questions.
Good news is you ran in here.
Good news is what, sir?
That you ran in here. You're here.
I did run in here, in my heels.
No, thank you. We'll continue with public comment.
Okay,
thank you very much. Lerone Rucker, care of Catherine Myrick. Welcome.
Thank you. Thank you.
You're here to speak on item 9?
Yes, I am.
Okay, go right ahead.
I'm just here to speak as a LA County resident and speaking for the African American community. We love that neighborhood on Adams, and I think it should be deemed as a historical residence. And the reason why I say this is there's a lot of cotillions, there's a lot of black, upwardly mobile people that know about this neighborhood, and we'd like to see it maybe stay kind of interesting and kooky and keep sort of the architecture of famous architects intact, especially if you have a building that has not been messed with since the time it's been built. Thank you, esteemed council people.
Thank you very much. Faisal Alsari from Council District 5.
Council members, good afternoon. Faisal Alsari on behalf of Councilmember Koretz. Again, we accept the CHC recommendation to not designate this property for historical status. I should also, or I should say, I would like to thank the representative for acknowledging some of the statements that were said and that they were incorrect. Just for the record, just to address some of the assertions that were made, and just for the facts of this record, we received requests to nominate this property on behalf of a neighbor who knows the home quite well. We additionally received a request by a member of the Homeowners Association, as well as a journalist from a reputable news organization. All of these requests were made on the belief that this property should be evaluated for historic merit. We never once received statements that this property should be designated in order to stop development in an overactive neighborhood, as was previously stated. Upon contacting the Department of City Planning, we were informed that this property may be of historic value and should be further explored. I believe here we've done our due diligence, and in accepting the CHC recommendation, the city should not move forward in designating this property. Thank you very much.
Thank you very much. Any questions or comments on this item? No. Seeing none, we'll move to concur with the Cultural Heritage's recommendation to decline the designation.
Second.
Second, Cedillo. Any objections? Seeing none, so ordered. Thank you. Item number 10.
Item 10, Councilman, it's a CHC report relative to the inclusion of the Carter Japanese Garden as a historic cultural monument.
Okay, staff here on this.
Good afternoon, Melissa Jones again with the Department of City Planning's Office of Historic Resources. Before you today is the Ethel Giberson Hannah Carter Japanese Garden Historic Cultural Monument application. Upon review of the application against the 4 criteria of the Cultural Heritage Ordinance, the Cultural Heritage Commission found the property to be an excellent and intact example of a Japanese-style residential garden and unanimously recommended declaring the property an historic cultural monument. The applicant, Adrian Scott Fine from the LA Conservancy, is available to provide a brief background on the nomination, and I am too here available for any questions that you may have. Thank you.
Okay, thank you. We'll move to the applicant, Adrian Scott Fine.
Good afternoon, Adrian Scott Fine with the Los Angeles Conservancy. We're here and have submitted this nomination in partnership with a local, state, and coalition of partners that have been working tirelessly really for the past 5 years or so to ensure that the Hannah Carter Japanese Garden would be protected and preserved. So at this point, we submitted the nomination to ensure that there was adequate long-term protection that would be afforded through historic cultural monument status. This is a significant Japanese designed landscape. It's considered one of the 10 best in the U.S., and it's recently changed out of state ownership through UCLA into private hands, and that's why we are pressing for its designation today to ensure again that there is protection for it and a process in terms of design review going forward. So thank you for your support.
Thank you. James Caldwell.
Hi, I'm James Caldwell. I'm actually Hannah Carter's grandson. I've been going to this garden my whole life. I don't know if any of you have ever been, but it's a really pretty remarkable place. It's a very, very special place. And yeah, my family's been working really hard over the last couple of years to kind of help ensure that it would be protected forever and be, there in the community and for the people of Los Angeles. And I think it would just be so important to get the designation of the historic cultural landmark, historic cultural monument, just to help protect it for the future. I mean, like I said, I think it's one of the most special places that I've ever seen, certainly in LA. And yeah, I appreciate you taking it into consideration.
Thank you.
Thanks.
Welcome. Okay, and from Council District 5, Faisal Al-Sari, who breaks our record for the number of times the council office comes up to speak on an item today in one meeting.
Council members, good afternoon. Faisal Al-Sari on behalf of Councilman Kretz. We support this designation. Thank you.
Thank you. Any questions or comments? I see none, but it's worthy of just noting the importance of this a real gem in our city, and it's great to see that we're going to preserve it through this nomination process. So I'll move to sustain the determination of the Cultural Heritage Commission and approve the designation. Any objections? Seeing none, so ordered. Thank you. I believe that takes us to general public comment.
Yes, sir.
Okay, we have one comment card. Levon Marie Rucker.
Thanks
Welcome.
for hearing me again. I just want to say for item number 8, thank you so much for approving it, because they need other things there besides a motel. And if you could, think about putting some speed bumps so people don't get killed walking across the street. For item number 10, I went to Bellagio Road Elementary School. I'm so happy that they have something cultural in that area that people that were bussed in can see and remember that elementary school, because it's gone now. Again, thank you.
Thank you. You know the city quite well. You've been everywhere. Thank you very much. Any other items?
No, sir.
Seeing none, this meeting is adjourned. Thank you. Nice and easy.